Welcome back to the Law and Crime Network. I'm Caroline Polisi. And guys, I have to apologize. I want to clarify. I went off on a crazy rant about a defense attorney calling a witness sweetie when I had the facts wrong. This is what happens when we don't get to actually see the interaction takes place. It was in fact the witness that called the defense attorney sweetie, saying that it was just another day in paradise. In that case, not so bad. So I'm sorry. I do apologize about that. I also have to clarify, it was Smith's teeth, the grill issue, that the judge took up right before the jury was, after the jury was sent out for lunch break. They're going to take that issue up at 1:15, but I do believe that they have decided they are merely going to show a photograph of Smith's teeth instead of sort of making him parade around for the jury, which makes a lot of sense. I'm joined today in studio with special guest Karen Desoto, a former prosecutor and now criminal defense attorney. Karen, thank you so much for being with us today.
Thank you for having me.
I'm excited to break down this case for you because,
okay.
I mean, just as you can see, even I got a few facts wrong. I mean, it's mind-boggling.
Right.
When you have three defendants,
yeah.
You're talking about, many different charges here.
Right.
Two juries.
Right.
I mean, that's the first thing I want to talk about.
Yeah.
Okay. So, you're a former prosecutor.
Right.
How typical is it to have two juries?
It's not typical at all.
Okay.
And first of all, most of the time, the motion to sever the cases is always granted a lot of the time. But if
it is granted?
Yeah, a lot of the times.
So
it's
I do
granted.
federal work, and most of the times, I think I've made. I routinely, if I have a multiple defendant case, I routinely make a motion to sever, and
right.
I don't think I've ever been granted it.
Right.
Maybe that says more about my motion.
Well, and it also depends. In federal cases, you're going to have more multiple defendants,
right.
Meaning that you're going to be doing organized crime stuff,
right.
You're going to be doing gang stuff, you're
right.
going to be where there's 10 or 15 different. In state court, if there's 2 or 3 defendants, you could do a motion to sever, and a lot of times that will be granted. However, it depends on how many witnesses, how long the trial is. Obviously, if you have multiple witnesses from DNA to blood spattering to investigators and they're the same people, obviously you have to go with the double jury because now that's going to cost double. Right? So even a judge is worried about efficiency,
so
right?
It's really an issue of judicial resources and
Absolutely.
Government efficiency,
Right.
Which I think is a good thing to highlight. I also think it likely makes it more difficult for the prosecution to present really conflicting theories of their case. Would you agree?
Absolutely.
Yeah.
I mean, there's a whole separate strategy that you have to use for a double jury. Also with multiple defendants, because you have a defense attorney for each one of them.
Right.
And their agendas sometimes are in line, sometimes in the middle of the trial it changes, sometimes they're together, and sometimes they're with one and not the other, right? I have a good friend of mine who will when she has multiple defendant cases, if she's not on the same page with them and she wants to separate herself from the other one, she slowly edges her client and herself to the edge of the table.
To create even a visual.
Correct.
Wow.
Right.
Interesting.
So, there are a lot of, as you know, a lot of psychological tricks that we use for that. So if you want to separate your client, you physically giving the jury that physical visual that you're not with these guys. Like, I don't know them.
Right. But there is sort of a code of conduct, am I right, among
Correct.
criminal defense attorneys. I myself know it well, that you don't sort of throw your co-defendant under the bus regardless of, look, your first order of business as an attorney is that you want to defend your client's rights, obviously. But if you can do that in a way that doesn't sort of hurt your other defendants, you try to do so as much as possible.
Well, your priority is your client, but there are instances where you may want to throw the other co-defendant, right? If it's them or me and it's your client, you really don't have a choice. So yes, there may be a code of conduct, but going into the case what the facts are, what you're going to be able to get away with. You're going to have consulted with the other attorneys on the case, right? So you guys all know where you stand when you go in there.
Right. I wonder, do you think that these defendants were having multiple co-defendant meetings prior to trial, getting ready for trial, or do you think that they've kind of decided on their own separate tactics here?
I think that they're probably, at some point, obviously, it's a murder trial, right? And in petty crime, you're going to have defendants getting together a little bit more. This is serious, right? This is
serious.
their lives, right? So obviously, in the beginning, prior to trial, of course, there's going to be negotiations. They know each other. They're involved with each other. Of course, there's going to be conversations, right? But hopefully, you're going to listen to your attorney, because your attorney is going to tell you stay away from them at this point. Why? Because people are being recorded. People are being videotaped, right? Because going to jail for 25 years is a long time, and you may be willing to do just about anything. So any good defense attorney is going to tell you to stay away. Let me talk to the other attorneys. Let's negotiate this the way that we're supposed to do it. That's what you hired me to do. Right? Don't be going off in the back alley having conversations with so-and-so's brother's cousin's sister to get a message to somebody either, because they all wind up on the stand. Right?
Witness intimidation.
Correct.
Yeah, that is not good. I agree with you there. I love having you here, because now I can ask you about sort of the prosecutor's mind. So we just heard sort of your take on the defense here, but so if you're the prosecutor in this case, I mean, from my perspective, I don't think they've really presented a coherent narrative of what they believe actually happened that night. Is that tactical on their part, do you think? Or is that just because they really don't know?
They may not know. And, many years ago when you train to be a trial attorney, they always say motive, motive, motive. But unfortunately, in this day and age, a lot of things happen where there is no motive, and we have road rage incidences, people being stabbed for no reason. We have increased mental issues where I think we've all witnessed at the mall and on the street very strange behavior that we've never seen before in the past 20 years. There's lots of medications out there, lots of new disorders that are being named every day. And therefore, motive has really kind of not as important as a prosecutor would think that it would be, right? Because people do things on impulse. We know with our juvenile delinquents and juveniles in general from research that impulse control is one of the major problems with them. So motive could be up there, obviously, as long as there's an argument motive. And not as important, use that on closing arguments. You can link it all up, not say a word, and then your strategy could be, I'm going to link it all up at the closing.
Right. And so what about in terms of, the fatal shot? In this instance, we have, of course, one victim, Benetria Robinson, age 19. Again, as far as I can tell, I don't think the prosecution has a clear idea of who actually discharged that gun. Does that matter?
Oh, of course it matters, because when you have multiple defendants, right, the criminal defense attorney's strategy is going to be, they weren't the one with the gun. I didn't do it. They're all pointing at each other, right? So as much as you confuse that as possible, the jurors may have also a problem. I had a colleague who had a murder case with 13 eyewitnesses, and she got a not guilty, right? So in that instance, if you can confuse the jury, if you could say, oh, this person, look, there was testimony, they couldn't identify them in a lineup, they identified them later, so the more inconsistencies for the jury, the more a defense attorney is going to play on that and say, look, there hasn't been any evidence, right? In the closing, you're going to say there hasn't been any evidence. There's been some eyewitness testimony. However, you heard that the statements were inconsistent. The prosecutor hasn't done their job, right? At the close of evidence, of course, make your motion to dismiss, right?
Yeah, we already saw one motion for mistrial. We already heard from. I want to take our viewers to a clip now of Detective Frank Scala, and we'll talk more with Karen when we come back.
Introduce yourself to the juries previously.
Frank Scala.
Detective Scala, on September 13th, 2015, did Wayne Counsel come from the Cloud9 nightclub to the Marion County Sheriff's Office?
Yes, sir, he did.
Did he come immediately after this incident had occurred?
Yes, sir, he was one of the first people I spoke to.
Did you have occasion to administer photographic lineups to him?
Yes, sir.
I want to show you first what's been marked as State's Exhibit 000. In this envelope here, can you go ahead and take that out and tell me whether you recognize it? You recognize that?
Yes, sir.
Okay, what is it?
This is the photo admonition form, and this is the photo array that I showed Mr. Counsel.
Okay. And who is depicted in this photo array?
This is in slot number 5, it's Gary King.
When you showed this photo array to Mr. Counsel, did he select Mr. King as somebody he could identify?
Yes.
What did he describe him as having done on the night of the morning hours, September 13th, 2015?
He put that he was with the shooter, which he ID'd as Laquan Barrow.
Okay. And does this lineup of featuring Mr. King appear to be in the same or substantially similar condition when you placed into evidence?
Yes, sir.
At this time, the state will move State's Exhibit 000 into evidence as State's Exhibit 65.
Any objection?
No, sir.
No objection.
State's Exhibit 000 for identification will be received in evidence as State's Exhibit 64.
Detective Scala, I'm now going to show you what's been marked as State's Exhibit PPP. Can you take a look at that and tell me if you recognize it?
Yes, sir.
What do you recognize that as being?
This is the photo admonition form and the photo array that I showed to Mr. Counsel.
Did he select and identify anybody in that photo array?
Yes, sir, he did. In slot number 4, Laquan Barrow,
And what did he identify Mr. Barrow as having done?
as doing the shooting.
This time the state will move State's Exhibit PPP into evidence as State's Exhibit 65.
Any objection?
No objection, Judge. No, sir.
No objection.
State's Exhibit PPP for identification will be received in evidence as State's Exhibit 65.
I have no further questions, Your Honor.
Cross-examination.
Thank you, Your Honor.
Detective Scala, in addition to conducting the photo array, you conducted an interview with Mr. Counsel that same day, correct?
Yes, sir.
Okay. And you would agree with me, would you not, that in that interview he indicated to you that Dee meaning Danielle Kendrick, had pepper sprayed him, correct?
Yes, sir, he did.
And not only did he advise that, but at some point he was trying to recall the name of Maisha, correct?
I believe so, yes.
And he indicated to you that as a result of the pepper spray, he was having a hard time memorizing that, correct?
Something to that effect, I believe, yeah.
Would you like to see exactly what he said to help?
Yes, you have.
This is page 19.
And welcome back to Law and Crime. I'm still joined here with Karen Desoto, former prosecutor and now criminal defense attorney. And Karen, we were just getting into the nitty-gritty of this case. And as I told viewers before, we weren't able to show the last two witnesses to get on the stand prior to the lunch break. Of course, court is now on lunch break in the Cloud 9 trial. And I want to talk to Karen a little bit about this issue, because the reason that we chose not to show these witnesses was at the request of the attorney, but due to safety reasons, because apparently there are some gang-related defendants here. Of course, the issue itself wasn't gang-related, apparently, but there are safety concerns. So I want to ask you a little bit about, as a prosecutor, how often do you see these types of issues?
All the time.
Okay.
And more and more. And what's disturbing is that it's very hard to even bring a case because of the fear instilled by gangs. We know that gangs are a problem. We know that they're an issue. It's systemic. And, you know, one day you may be prosecuting a person and the next day they're a witness for you in another murder case. So there is a lot of affiliation, a lot of rules being broken with gangs. Obviously, you want to protect people. It's so hard to get people to testify. They're frightened, they're scared. Their families can be threatened. So you always take these type of, whatever you can do to try and protect somebody. And that doesn't always work, unfortunately. Obviously, in this case, we had 2 witnesses already who got contempt for not answering that. So as a prosecutor, I'd be all over that, right? They won't answer. Obviously, they're scared, and if they're scared and they're not talking, then there must be some truth involved here. Right?
Absolutely.
So the prosecutor has to do that, but at the same time, you have to protect the person on the stand. It's very hard to judge a person who doesn't want to testify that really is concerned about protecting their family.
And just from my own limited experience in this arena, I usually do federal issues, but I have represented a cooperating witness to a murder trial, and he actually had to go into witness protection afterwards. And so I worked very closely with the government to sort of get him on the ground. And this is a big deal to go into witness protection. This guy had a family. He had to, get his kids in school, different places. It's
memorizing a new social security number.
Exactly. So
alone.
Right. So what are the resources in place at the government's disposal to sort of protect its witnesses if they really want to move forward with this case?
Well, it's hard, and obviously there's a difference between being in the witness protection where you have those type of resources. In state court, you don't have that, right? At the very least, I'll have a guard meet you at the front door, right?
Ooh.
And there's been many cases where I can think of 2 cases that have been covered in the news where it was a domestic violence situation and she was burned on the, thrown gasoline and burnt on the front of the courthouse steps.
Oh my gosh.
So meeting somebody in front of the courthouse, I would always say, well, that's great, but they still have to walk from the parking lot here, right? Sometimes you can get police escorts because state, again, resources are limited, unfortunately, especially in urban areas where you have lots of trials like this. And in urban areas, you're going to have more issues like gangs, but you'd be surprised how that leaks into suburban areas as well. So there's limited resources. What can I tell you? Budget concerns. People who want to see these trials, they don't understand, especially if they're very high profile. Oh my gosh, you're paying staff overtime. You have to pay even extra security. You have to pay, stenographers to stay over. You have to have more guards. So the amount of money and budget really is a serious concern because that money is being taken away from other investigations, other resources. And then when you're up to do your budget, that's an issue. And I'd love to say that justice, doesn't have a price tag, but unfortunately it really does.
So true. But so then given that, can you blame these witnesses, these contempt witnesses? I mean, they're willing to go to jail for 6 months. Clearly they fear for themselves, for their safety, for the safety of their family. What are they to do? Clearly there is some power out there that they feel is above the criminal justice system.
Caroline, I think that somebody who's willing to go to jail for 6 months is a pretty serious threat, meaning that there is a viable threat. And I would be concerned as a prosecutor for their safety. Of course I want them to testify. I want this person to be responsible. But unfortunately, trying a case may mean more casualties. Right. So,
and just to clarify for our viewers, it's not an issue of whether or not that defendant goes to jail or is convicted because, of course, from even behind bars, these guys have tentacles in the community. They can put hits out on people. They have power from behind bars, which is a terrifying prospect.
They have people visiting them all the time. I mean, we know we've had cases with the even with the people within the Department of Corrections. I've had cases with the people who work for the Department of Corrections, bringing in cell phones, huge problem. There have been 2 articles in the newspaper recently within the last year that somebody was using carrier pigeons to bring in cell phones or drugs. Carrier pigeons.
You can't make this stuff up. Wow.
Because people are always, don't understand how it is that all of this is getting into the prisons. Right? So if you're able to get cell phones and drugs and alcohol and other items into the prison, what makes you think you can't get a message?
Right, absolutely. I think that's a very important point. There is often, kind of a gray area between the people that work at the prisons and the inmates, and it's a scary, scary thing.
They don't get paid as much as, depending on where you're at. Some of them get paid but they're not getting the same as a police officer or a sheriff's officer. Usually it's much lower, so it can be enticing.
It's quite a shame. Let's switch gears here a little bit. What do you think about the strength of the prosecution? By the way, guys, is expecting to close its case today. So I'm personally very excited to hear the defense's case, see what they've got up their sleeves. So what do you? I mean, just as a baseline, a lot of people are saying, look, all they've got really are eyewitnesses. Is that enough to convict?
Of course it is.
Okay.
Yeah, of course it is.
Says the former prosecutor.
Right. Of course it is. Of course it is. I mean, if you're, and it's up to the jury. It's the fact. But in this case, there's eyewitnesses, right? I mean, this is really kind of a horrifying scene, right?
Oh yeah.
Somebody's going to jail for it. The jurors are not going to say, okay, maybe it was an accident, right? This is people shooting into.
And the beautiful victim, Benetria Robinson, just 19 years old. It's just tragic.
And her brother. The whole circumstance of it is really very disturbing.
Yes.
So the jurors already, having seen the photos, having seen the dash cam video, right? So they're already on edge. So yeah, I'd like to tell you, right, everybody watches Law and Order and CSI, and it's amazing how many people want to see DNA,
the database,
blood spattering.
Yeah, exactly.
I want to see the fingerprint analysis. I want to see all that CSI stuff. So in this case, obviously, we don't have a lot of forensics. We have Barrow, who has some residue on his hand.
Right.
But you had enough direct testimony with Mr. Defendant Barrow to really close the case. So it's circumstantial, yes. The other two, you're really, really relying on the testimony. So now this is interesting because this is real lawyering, right? This is real direct and cross-examination. This is using inconsistent statements, using impeachment, trying to get them to change their story or what are their biases and their motives, right? Because if a witness is telling you, I saw them do that, and you're saying, but my client didn't do it, right? What are your options? And your options is to discredit that witness. Either they're lying, they didn't see it correctly, right? You have limited options. So that's all you have. So there were a lot of witnesses here that had really strong testimony, that were independent witnesses, that were not correlated to any of those people. And for that reasons, the jury is not going to weigh that against them.
So interesting. So you think, for all three defendants, you feel the prosecution has presented a strong case?
Not for definitely with Defendant Barrow.
Absolutely. Agreed. I'm right there with you.
Absolutely. The other two, the witnesses and the testimony wasn't very strong. There were a lot of holes in their testimony. Ultimately, it's the juror to really pick up on whether or not they think that they're credible or believable. Maybe they have some kind of motivation. That was brought up in two of the cases. One of the witnesses, I forget what her name is, but she said, she just wanted to help out. Or she wanted to, right? So those things, you're going to get a jury instruction at the end from the judge saying that it's up to you, the jurors, to weigh the evidence and you decide whether they're credible. You use your instincts to decide whether or not the person is being, right? And of course, I'm going to stand up and say that you have to be firmly convinced beyond a shadow of a doubt. That standard is really high. The testimony, I'm going to ask you to that witness wasn't credible. That witness, as you saw from cross-examination, told you two different versions. She said that she was just trying to help out. That's not something that you should be weighing in here. What I want you to focus on is this, right? Mm-hmm. So obviously, that's going to be part of your strategy. But, when you go to trial, there's always three things that you don't know when you get there, and you really have to compensate for what the testimony is, what the person, people have said stuff on the stand that, it's only been a few times in my career that I've been thrown, but people do things.
But what I love about Florida,
right?
They get depositions in
yes.
criminal cases.
Isn't that fantastic?
So, that blew my mind when I heard
Florida
that.
has all kinds of very strange.
What's
strange
going
rules.
on with Florida?
Releasing all of the information to the public is, at least as a former prosecutor, I think that's bizarre, right? Because there still may be other witnesses out there. In the Casey Anthony case, remember they were releasing all of the telephone conversations with her mother. Right, and that was on the news every night.
Right.
So Florida, and of course they give out guns like M&Ms. That's another problem. That's one of the reasons why we have these cases.
Yeah, a lot. We've covered back-to-back Florida trials here on the network. So many cases out of Florida.
Something in the water.
Yeah, exactly. But the deposition thing, as criminal defense attorneys, we think that's weird.
It is weird.
It is. It's really weird because typically that obviously is only available to a civil litigant.
Right.
So that kind of does change a little bit in terms of you really do
does
maybe
change.
know what they're going to say on the stand.
You do,
Yeah.
because usually what happens is if I'm a defense attorney and I send an investigator out, a lot of the times they're not going to talk to the investigator, right? But if you have a deposition where they're sitting there and you can ask questions, you know where it's going to go.
Right.
And of course, for impeachment purposes, you may have an investigator's report, you have the original police report, you may have the public defender's report, and now you have a deposition. So the chances, it's better for the defense attorney, really,
is.
because if you have 4 different transcripts, you can argue semantics, or you can try and trip them up and say that you said this here, you said this here, you said this here, and it was different here, which one is correct, right? Jurors are a little bit more keen to saying, listen, you're just arguing over semantics, or is it something substantive in each one of those, right? I had a rape case once where in one transcript they said he was slithering like a snake, and in another transcript it said he was crawling on his hands and knees.
Ooh,
right?
That's good.
So something like that, the jurors are going to be like, you know what? We don't think you're credible. So the more chances that you get to interview or question a person, the more chances it is that if they in fact are lying, they're going to trip up, right? Because not many people are the best liars.
Right.
Sociopaths actually are pretty good liars. They
Yeah,
remember
they are.
what
I've
they
met
say.
a number of them, and they're fantastic.
Charming.
At
I never met a
charming.
sociopath I didn't like.
I know,
right?
you and me both. Isn't that funny how that works? Okay, let's get into the nitty gritty
Sure.
here. So 21 shots fired this evening. We
Right.
know there were 3 gunshots. I think 4 came from one, 4 came from another, and
Right.
12 or 11, I'm not good at math,
Right.
came from the third one.
Right.
So the way the prosecution chose to charge here, all 3 are charged with that second-degree murder
Right.
of this victim that we have
Yes.
in the case, Benetria Robinson. Now,
Right.
just to I just want to clarify for our viewers, that doesn't mean that the prosecution necessarily needs to rely on a single theory about who made that fateful shot.
Correct.
Well, why don't you explain it for us?
Right.
Yeah.
So obviously, if they were all involved, they can all be charged the same, no matter, as long as you can make a connection between them and the actual shooting, right?
So break that down for us, because I think
Right.
that's really important, because I
Right.
think it tends to be confusing sometimes.
Well, it depends on each state,
Right,
as well,
exactly.
because you can have manslaughter, and then if you're arguing lesser included offensive, and the lesser included offenses are different for each defendant,
Exactly.
it has a tendency to get. So prosecutors like to try and keep it clean.
Right.
Obviously, defense attorneys would rather them do the higher charge and not do any lesser included offenses, so that jurors can't say, hey, all right, it doesn't seem strong enough for that, so we're going to give them
Right.
the lesser included offenses.
And in some cases, right at the end of trial, the lesser includeds go in there. I mean, it's crazy.
and that's confusing,
Yes.
because as we know, that overturning a trial is never on the evidence. It's always on the technicalities correlated to jury instructions.
Yeah.
All the time on a technicality, right? So there's a very low chance that you're going to get your case overturned, but if you do, it's not going to be because, there was not enough evidence, which
Right.
is what everybody argues, but it's going to be the jury instruction was wrong, they shouldn't have done the lesser included offenses, stuff like that. So you really have to be on your game, right?
Right.
So, which is one of the reasons why it's so difficult to be a trial attorney, because at the same time you're trying the case, you're also writing motions,
Right.
you're also doing jury instructions, and it's a very sleepless, very
Yes.
horrible experience. Makes you age very quickly.
I know.
And at the end of it, if you screw up, somebody goes to jail or dies.
Yeah,
So
high stakes.
it's a lot of stress.
High
So-
stakes, certainly. So in this instance, the prosecution, the top charge here is that second degree charge. We've seen a lot of our other trials here on the network charging that first degree charge with premeditation, but the second degree doesn't necessitate that premeditated
Right.
aspect. And in fact, merely shooting into a crowd would evince the requisite level of
Right.
sort of malice and generalized
Depraved
depraved
mind.
indifference, or
Right.
every state has a different buzzword, but again, the second degree murder charge, it doesn't, the prosecution doesn't necessarily need to prove that person discharged the gun, but merely that, as you were saying, merely was sort of connected in some way,
Right.
which I think is a little fishy here.
It is a little
iffy.
fishy.
Yeah, because
Not
you
for Mr. Barrow. I think
Right,
they
right.
nailed it on Mr. Barrow. But the other two,
Agreed.
that's going to be up to the jury. And if they're horrified enough by the way that it happened, if there has been some testimony that slipped in about gang affiliation. Right? So these are the things as a prosecutor I'm going to want to put in there, because once people hear gang affiliation, they're like, oh, okay. All right, that's what was going on here.
It's almost like a conspiracy charge, really, that the prosecution needs to prove. And when you have such a chaotic scene, and you're not sure. I mean, the likelihood that these three guys sort of got together and said, "Hey guys, let's all do this together." I mean, seems a little far-fetched.
But if you can bring in that testimony that they're in the same gang or they're involved in gang violence, people automatically will say, "Well, that's why they did it. They did that. They're like a family." Right? And not just a family, a criminal family, right? So I think getting that testimony in is very important, and you would slip that in wherever you can. With your witnesses that you blurred out or that you were worried about their safety, that's something that you would broach with them, right? Or depending on how far the judge lets you go with that. But you're going to put that in every time that you can, because it really kind of explains the behavior, doesn't it? Because what normal person, what reasonable person, even if it was your friend, I'm sorry, if we were out for a drink and you started shooting somebody, I'm not going to take the gun and hide it and put it in my purse for you.
Absolutely.
Right?
You wouldn't do that to me?
Maybe.
I mean,
It's
we just met Karen, but I thought, I just feel like this could be something.
Exactly. I think most reasonable people wouldn't even do that for their relatives, right? Maybe a mom with their son, right? Depending, maybe a best friend that's like a brother or a sister, or a brother and sister. But what you need to really explain that whole to the jury. You really need to explain, why is it that somebody would behave in this manner? And as soon as you say gang, listen, people watch TV, they know what goes on in their own communities. As soon as you say that, it's, that's why they did it, right?
Right. Interesting. We're just minutes away from going back live to the Cloud 9 courtroom, but while I have Karen here with us, I want to keep talking a little bit about this. I hate to put you on the spot.
Sure.
But I love to do a conviction prediction. So, here on the network. So I will go first.
Okay.
So just, of course, again, guys, we have not seen the defense's case, but the prosecutors are expected to rest their case today. My prediction is that Barrow will be found guilty on all counts.
Right.
I think that King and Smith will not be found guilty on the second-degree murder, but will be found guilty on the attempted. That's my conviction prediction. Right. What about you?
I actually agree. I know. I wish I could say differently.
Okay.
I mean, it's one way or the other. All three will go, or it's going to be the way that you said it was. And it really depends on whether the jurors, how horrified they were by seeing the pictures, by listening to the testimony, right? The idea that 5 other people were shot and wounded, that's a miracle that they even lived. But the scene and the chaos and the videotape in the beginning with the police officer, the description of the police officer as she was dying, that's... So, I'd like to...
depraved indifference. I mean, to shoot a gun in a crowd of that size...
Right. They don't have, and I don't think they have any problem meeting that element. Right. And here's the problem as a defense attorney. Is it the 2 other defendants that you may have some shaky testimony? Are they going to go down because of this person? Which is the same reason why my girlfriend will move her body way down to the end of the table to try and separate herself, because it's that strong, right? And it's really that desperate, right? It's the difference between spending the rest of your life in prison and, maybe getting out and, getting into a second chance program and maybe having a life for yourself, right? So these are serious issues. And I think that jurors really take it seriously, but when it's this severe, when you're at a club, when there's people around and you're just shooting into a crowd and then you hear gang affiliation, then there may not be any mercy, is what I'm saying.
Right.
And that really depends on how good you were picking the jurors. It depends on what their bias and motives are. Depends on whether or not they themselves have been victims of violent crimes, whether brothers and sisters have been victims of violent crimes. And sadly, your jurors, depending on what your area you are, have been exposed to that. So what is it, the psychology of it? And really, it comes down to, did you pick the right jury?
Speaking of jury, and we're just hearing now that court is getting ready to go back live, so we're going to take you just as soon as we can. But how do you think this element of, do you think that there have been any interaction between the two jurors? I don't know how the procedure works. Are they all having lunch together? Like, are they, do you know what I'm saying?
That's interesting, and actually that would be something that you would discuss even, when you're doing your motion in limines, right? Are they, and yes, no, you have to keep them separate.
I would assume, right.
Right, so that it's not going to be like they're going to be like, okay, today we're having lunch together.
Right.
And one thing that I think it's important viewers who are not attorneys understand is that jurors and the way that you're supposed to behave in front of jurors is you get a long instruction. I make the judges in my cases say 3 times that if they see me in the hallway, in the elevator, you can't say hi, you can't. So please don't think that they're being rude. And
right.
I will make them, every time he discharges them, I make him, please, can you say that? Because they're looking at me and I don't even want to smile at them. I get into the elevator, I'm in the corner, right? So this is, it's serious stuff. People's lives are in matter. People have died. People have been fatally wounded. These are wounds that they're going to have for the rest of your life. And jurors do take their job seriously.
Yeah, I think it's such a good point. Oftentimes, the only time that an attorney really gets to actually address the jury, openings and closings, and we've had many people on talk about this issue, the bathroom issue, right? You're waiting in line with a juror. There's, in small courthouses, in rural courthouses, maybe there's, I always, in my case, I always go to another floor to go to the bathroom. Because I don't want to run into
away from them.
Get away from them. Just don't even go there. But some attorneys don't have that luxury, and they're literally in the bathroom with their jurors, and which is why it's so important.
And if they have a conversation or try and have a conversation, then you have to go and tell the judge. It really is a big deal. I don't think people realize how serious that is. It's an ethics violation for us. And if there's even like, hello, how are you doing today type of a thing, you're supposed to go and report it to the judge, right? And a lot of times they're like, oh, whatever, that's not a big deal. But unfortunately, that is a big deal these days, especially because people are in the bathrooms with their cell phones, they're Googling. Attorneys have been reporting jurors that are in the bathroom with their cell phone Googling, and it seemed to me like they were looking at their news feed. They were told not to do that, right?
Are they allowed to have their phones?
Each judge is different. Judges often will not want to not take away their phones fully, even though they'd like to, but unfortunately one of the problems now is social media and their phones. So the more serious the case is, the more the judge is going to want to take it away, but because people are so, at least I perceive, so addicted to their cell phone, the jurors get angry when the judge says, I'm going to take, what? You're going to take away my phone? Or are we going to have it during breaks? Because there's such an addictive nature to it. So, the judge already doesn't want to do that because he knows that people are going to get angry, right? I want to check my emails, I want to check, but the problem is, what are they seeing in their news feeds? They're checking their Facebook, or if this is a higher profile case, right? And even if it isn't on the local level, there's going to be, right, newspaper articles, there's going to be people texting you like, hey, how's that trial going, right? So you want to take their phones away, but it's like taking a phone away from a 12-year-old, even with adults. They don't want to do it. So it's serious. And a lot of the times with the cases where it's been reported by other jurors. It's been reported by the attorneys involved in the case. There was one case where the juror friended the defendant in the middle of the trial.
Wow.
Right?
Wow.
Did a friend request to the defendant during the trial. So these modern technology issues are really a big deal.
Yeah.
And people would be like, oh, well, who would do that? Well, I don't know. Who would do anything?
Exactly.
These are real cases, and people do unusual things these days. And
we live in strange times.
We do. And, that's something that judges have to prepare for, and also prosecutors and defense attorneys have to be very aware now.
Yeah, it also is an issue when you think about a high-profile case when juries are sequestered. I mean, that's like, jurists hate that, right?
Yeah,
I mean,
of course.
think about
they
that.
start to go crazy.
They do. They
while,
really do.
right?
And I think we've
Could
seen.
you imagine being sequestered without your phone?
I know.
Oh my God.
It can't
what
think
would
of
I
anything
do?
worse. I mean,
I have to see what everybody had for lunch today. Yeah,
exactly.
But
exactly.
That's something judges normally don't want to make the jurors angry. Why? They're volunteering their time. You want to be as kind and as courteous as you can, and be stern and disciplined. That's really, it's like a parent, right? You want to be, you can't do this, you can't do that, but thank you so much for being here, right?
Right.
And
I like to clarify, they're not really volunteering. It is their civic duty as a member.
Yeah, they're
member
volunteering.
of our fine country. They are required.
I've been trying to get on a jury for years. Only me, though. Only me. Everyone else is trying to get out of it.
I know.
Right?
I know.
It's too long, especially if they're 1 week or 2 weeks. People, a lot of employees, if they have their employers will let them, they're fine with that. But a lot of people don't want to take the time, and that actually is a really huge issue in many areas. I've wound up with jurors that were all seniors because they were the only ones unemployed. Everyone else had excuses. So how does that change the dynamics of the case, right?
I've heard about this. It's kind of a race to the bottom. I think I've read a few articles about that now we're seeing juries that are just, as you said, either unemployed millennials or
elderly
seniors, and it
two very
different.
Right? So actually, there's in the profession, people throw around the idea of having a professional juror, somebody who would actually get like a little 10-hour course, kind of like guardians and guardianship cases. They get a little training session, and then they get paid.
Ooh,
they get paid,
that idea.
right?
I've
a
never
professional
heard about
jury,
that.
Wow. So that is a very interesting idea, and I think that I don't know, that may take some interesting ferreting out the pros and cons of it, but it's very odd because it's no matter how good you are and no matter how well you're trained, because there's so many different types of personalities these days, it's really hard to get, and on top of it, the judges aren't letting you ask questions, voir dire questions, right?
Right.
So in the beginning of the case, we get to ask these questions. What kind of bumper stickers do you have?
Yeah.
What kind of newspapers do you read? What kind of organizations? Well, you know what? Some judges let you only ask very limited questions, right? So because of social media, because of access, especially if it's a case that's being covered in the local, you may want to or be able to get more voir dire questions. And you also may be able to get more questionnaire questions, because the problem is, especially with social media, if you ask them in open court, they're not going to be honest. If I say to you, how many times do you check your phone?
Right.
None.
I don't do it at all.
Once during lunch or once in an hour, right?
Yeah.
So right there, you're not going to be truthful, and you're not going to be getting the information.
Right.
So there's
They
all
probably
of
don't know
these.
themselves either. They probably
they
are
know,
lying to themselves, right?
Every time I hear that ping, I look at my phone.
Right.
Who's going to say that?
Right.
People aren't going to answer effectively.
Right.
So that'll also, so there's all of these issues on the makeup of making a jury. So maybe a professional juror maybe isn't so bad, right?
I like that idea. I'm going to think about that. That's very interesting. You just piqued my curiosity, so I'm going to do some research on that. Do you poll your jurors after?
I try.
You try?
Yeah, I try.
So
Sometimes the judge will let you. I try.
So what are the rules about that?
Well, I'm also a professor, right? And I have an advanced degree in trial advocacy. So I love to sit with the jury, and if they'll let me ask questions, but a lot of the time the judges will not.
Right.
Let me poll the jury, and then afterwards, can I talk to them afterwards?
This is on the prosecution side or on the defense side?
On both sides.
Okay.
But that's me, right? Because especially, of course, your chances of talking to them after a mistrial are even less.
Right.
But obviously you want to see what was it, what piece of evidence was it the testimony of this person, right? And it's surprising because when you do get that information, attorneys are often surprised that their strategy or the pieces of evidence.
I'm sorry, I'm going to have to interrupt you because we're going to go live to the courtroom right now. We're back in the Cloud 9 trial out of Florida.